All right, good afternoon, everyone. Welcome to the Joint Ventures Workshop presented by the Bonding Technical Assistance and Contracting Program and the SoCal Regional Contractor Development and Bonding Program. My name is Carlos. I'll kind of be helping run things behind the scenes for today. But before we get into our presentation, we just have a couple of housekeeping notes we'd like to go through just to set the foundation for today's workshop. So just a little bit about participation. I know we're all like Zoom virtual call veterans by now over the last 3 years or so doing this. So just want to reiterate, if you have a question, please feel free to use the raise your hand feature or just use your voice to ask questions. We'll also be monitoring the chat to make sure we get your questions there. But we would love to get that human interaction and hear your voice and have some dialogue. Also make sure, we would love to see your face too. So if you're in a position where you can be on camera, that would be great. If you ever presented on Zoom, you kind of know talking to names or pictures isn't fun, but we would love to see your face and get that interaction there as well. And then the main thing is just to be an active participant. You get out what you put in. So just participate, ask questions. We've set this up for you to get information on joint ventures. And then the last thing is you don't have to change your name, but if you could just enter your name and your company name and maybe even a phone number or email in the chat for us, that would be great. So we know who's all here. That would be great. So that's all I have for that. Any questions so far? No. Okay, cool. I'm doing a good job of explaining this. Good, good. All right. So today's speakers, we have Mr. Aaron Flores and Mr. Peter Ryan, who are going to do the presentation. But before we get to that, I know Anna wanted to say a few words. I'm not sure if she's in yet. If not, I don't see her here. So maybe we'll come back to her at the end. She'll say a few words about the BTAC program. So if there's nothing else, I guess Aaron and Ryan and Peter, I will kick it over to you guys and we'll get started.
Great. Thanks so much. Carlos, thanks for having us, and Rosa and Anna. We really appreciate the opportunity to present these seminars and share the information and experience that we have. I'm just going to go ahead and share my screen and start the presentation here. So first, just a little bit about our law firm and myself and Peter. FloresRyan LLP. We're a construction law boutique law firm. And what that means is, we specialize in construction law, everything from transactional issues to litigation and compliance issues. So, from soup to nuts, beginning to end, we do everything in the construction industry when it comes to legal issues. Peter Ryan, my partner, he's been a lawyer for 7 or 8 years now, focusing in construction law. He also has a good amount of experience working for construction companies and working in the field, doing bids and estimates and takeoffs and things like that. So not only does he have a lot of legal experience in the construction industry, he has a lot of just experience in the construction industry as well. The same is true for myself. I grew up in a construction family, so I'm very familiar with projects, how they run, all of the intangible issues that are associated with running a successful construction company. And my entire legal career has been dedicated to the construction industry, whether we represent owners, public or private, or contractors, subcontractors, suppliers, manufacturers, and things like that. So when it comes to disputes or legal issues in the construction industry, we've seen it all just about, and we've likely also taken those issues to trial or arbitration or mediation and gotten favorable outcomes. So we've got a fair amount of experience dealing with these types of issues. And when it comes to California joint venture law, we've got a good amount of experience, and we think some insights that we can share with you today. And hopefully you can take these insights as well as a copy of this program and utilize it for your own operations if and when you get to a point where you think that you might want to start a joint venture or be a part of a joint venture. So the agenda in terms of what we're going to cover today is, I think, probably can be broken down into 3 parts. But these are the activities that I want to cover. The first part here is really just to conceptually define what a joint venture is. So we'll get into that, explain conceptually what the joint venture is, what it does, and legally what the elements of a joint venture are. And that'll be item 1. And then items 2 through 6 here on the agenda are really going to be focused on getting into position. And what I mean by that is getting into position to have a joint venture and to be in compliance with the multitude of things that you have to do as a joint venture in California to make sure you're not running afoul of any rules or regulations. And that's important, right? We want to be in position, we want to be in compliance, and make sure that what we've set up is going to have its intended objective, which is to be profitable. And the third part of the seminar today is item number 7, which is a Q&A. And we've prepared a handful of questions relating to the topics that we're going to cover. And hopefully that will create and help facilitate just a conversation about the issues related to joint ventures and the materials that we've covered today, and give everybody an opportunity to ask questions. But as we go forward in the program, please interrupt us, ask a question, put it in the chat, turn your video and your voice on, and feel free to interrupt. We would like this to be as interactive as possible. So if you got a question, just go for it, ask it. Don't wait till the end here, but you'll have another opportunity at the end to ask questions as well. So without further ado, let's get into it and talk about the first big issue, which is what is a joint venture. In our experience, there's a lot of pressure on smaller business entities in the construction industry who have certain certifications. Maybe it's a small business entity certification, a disadvantaged or minority business entity certification, a women-owned business certification, or a variety of other different certifications that sometimes public owners and private owners request to have on their projects in order to either award a project to a contractor or to give a contractor a bid preference. It could be as much as a 5% bid preference other bidders. And so there's circumstances in which a lot of times you'll have two different construction companies coming together for the purpose of taking on a new construction project. And a lot of times what we find is that one entity will be smaller with these various certifications and perhaps not a substantial amount of bonding capacity. And the other entity will be much larger, right? They'll have much larger bonding capacity, but maybe they don't qualify for some of the certifications that the owner or the general contractor is wanting. And it's really the coming together of these two construction companies to act as one unit for the purpose of benefiting the owner. And legally, this is the definition of a joint venture. A joint venture is an undertaking by two or more persons jointly to carry out a single business enterprise for a profit. And I've highlighted a couple words here to really drive this home. But the first key word here is jointly, right? You have a lot of times a large entity and a small entity working together jointly as one unit, and they're carrying out a single business, and that is intended to be really geared towards a single contract when it comes to the construction industry. So maybe it's a contract to act as the general contractor to build a project. Maybe it's a contract to act as a subcontractor and perform just a discrete scope of work on a project. But it's one business, and they're doing it for the profit, obviously. And a lot of times clients will come to me and they'll ask me, hey, I want to set up a joint venture to get this contract with this larger entity. We're going to make a lot of money. It's going to be good. And I will try to counsel my clients to really evaluate the metes and the bounds of where this joint venture is going to go in terms of what's going to be required in terms of resources for the joint venture, how the joint venture is going to be set up, and all of the other variety of things that are required to set up a successful joint venture business. And what I commonly find is that amongst my either younger clients or smaller clients, there's kind of an awakening. You know, if you run a small business, you've gotten to this point where you're owning it and you're running it and making money. You've done a lot of work to set up that company, whether it's creating the entity, getting the license, getting your insurance, getting your workers' compensation, making sure you're in compliance with the DIR and paying prevailing wages, a whole list of things that you've had to do to set up that company. And when it comes to creating a joint venture, what you're really doing is committing to do all of that again and set up another business, which is going to be the joint venture. And so if you think about the level and attention that you paid in setting up your original business, now plan on essentially doubling that effort. And that's really what's going to be required to have a successful joint venture relationship on a project where you can actually make a profit. So in terms of the big picture, right, it's two different companies coming together to carry out a single contract for a profit. But what is involved in setting that up is going to be nearly the same, or perhaps in some situations even more than what was required of you to set up your original business. And so there's three basic elements to the joint venture. There has to be joint control, right? So I'm going to use the example throughout this presentation of a large contractor and a small contractor, but there must be joint control. There must be a sharing of the profits, right? Both parties are there to make money, and there must be an ownership interest by each party in the enterprise, right? They had to have an actual stake in the profits and the losses, not just receiving some type of income from the joint venture. So it looks like we've got a question from Jean Franklin. So Jean, would you mind just go ahead and ask your question?
Yes, thank you. I'm so excited. I'm so glad that this workshop is taking place. I'm looking at possibly doing a joint venture for my company, Jasara Construction Source Company. We provide labor support and targeted local outreach for construction work, for contractors and general contractors. And we provide licensed construction workers for contractors. My question is, as a professional organization, we provide services. Okay. So in order to get, and we're looking at long-term and looking at a joint venture where we can possibly connect with estimators or some engineers or project managers to go after a particular contract. So I'm looking at it as how would we go about doing that? And also, I'm also looking at RMOs, responsible manager officer. Could you give me, the pros and cons for that? I hope I'm making my question clear.
Yeah, you are. It's a great question. And I think this seminar is going to answer all those questions for you. And in short, what I can tell you is, what's going to be required in terms of your joint venture to make sure you're establishing a joint venture is, is there joint control between you and the other party or parties? Is there sharing of the profits for the business activity? And will each member of the joint venture have an ownership interest, right? And that's the first threshold to say, are you in a joint venture relationship, or are you in some type of like broker relationship or some other form of relationship? But if you're in a joint venture relationship, because you can answer yes to all of those three elements, then you're going to have a series of other questions, which are really more in the area of compliance. And you mentioned the responsible managing officer. So a responsible managing officer is someone who qualifies the contractor's license to be issued to the joint venture. or to whatever entity is receiving the contractor's license.
Right.
So as a little bit later in the presentation, we're going to have a section about contractor licensing and what's required for the licensees and the joint venture as well. But in short, I'll tell you that the joint venture has to have its separate license. So as we go here, ask yourself these questions: is there joint control? Is there sharing of the profits? Will each person have an ownership interest? If you answer yes, then you will probably have a joint venture. And then the question will be how it gets licensed. So
Right.
remind me when we get to the licensing slide if I don't answer your question, and we'll drill down and make sure that you have an answer.
Okay, great. Thank you.
My pleasure. So the big question to begin with is, are we in a joint venture relationship, or are we in some type of other relationship? And as Jean mentioned, she described a situation where it potentially may not be a joint venture. Maybe it's some other form of relationship. And so it's important to, narrow it down and say, do we satisfy these three elements, or do we not? If we do, then we've got a joint venture. And Peter's going to talk to us about how to actually create the joint venture itself.
Thanks, everybody, and thanks for joining us today. So when we go into the actual process of considering how a joint venture is created, I like to separate it into three categories. The initial step is always the due diligence. And the reason for that is, while there are tremendous benefits to operating under a joint venture, there are also some considerable risks, because you're sharing profits, you are sharing bonding capacity, and you are sharing potential liability. And you're going to be essentially running a business with this other partner. So the most important initial step is this due diligence. And the first part of that is understanding what the other potential member to the joint venture expects of you and what you expect of them, and that the parties have the same expectations. Ultimately, these expectations should be memorialized in an agreement. But before you even get to that point, understanding at a broad level, okay, well, what are my motives? What am I trying to get out of this joint venture? Am I trying to qualify for a specific project? Do I need more bonding capacity? Do I need expertise in a particular locale where this potential joint venturee is doing more business than I'm doing? So there's many different motivations, and you may have different motivations than your joint venture partner, but it's important to understand what those motivations are, so that at least you understand where you're both coming from, and so that you fashion your joint venture agreement accordingly. The next, even more important step is confirming that your potential joint venture partner can honor their share of the obligations and what you expect of them. And that breaks into two components. One is the financial side of things, and then the other side is the personnel, risk management, licensing, the intangible side of things. Financially, while it can be uncomfortable to open up your books to an outsider, it really is essential if you're going to essentially be doing business with this other business and forming a joint venture to have full disclosure of financial standing. And then the other side of that is exchange of information regarding, okay, who are the key personnel? How are these personnel going to work together? What's the status of the licensing? What needs to be updated with respect to the licensing? And even things as far as references. Because this relationship really is the merging of two businesses for the purposes of whatever project you're going after, it's almost like you're interviewing the other business and the people in that other business to make sure that it's going to be a good fit, and that you're comfortable that these people can fulfill their obligations. Aaron, move to the next slide, please. So once you've taken those steps, this due diligence, assuming that you feel good about your joint venture partner and you want to move forward, the next step is to form what we call either a shareholders agreement or a joint venture agreement. And at a bare minimum, there are 7 elements that you want to include in that agreement. Aaron will go into some of the stuff in more detail in later slides, but we'll cover it briefly here. First is the initial capitalization of the joint venture. Both sides should have skin in the game as far as capitalization for the endeavor. As Aaron mentioned, the joint venture, you are splitting profits. That means that you should be splitting risk as far as financial contributions. Some of that obviously comes in the form of bonding capacity, but there's also the capitalization that's necessary to finance the venture. And then the second one is consideration of additional financing. If you intend to take out loans in the name of the joint venture under which both entities will be obligees, most likely you'll be applying for bond capacity for the joint venture under which you probably will have your current sureties both participate. So considering the financing issues is another important thing that should be spelled out in the agreement. So that's the type of investigation that you want to do as the initial agreement is put together. And while some of this might take legwork, you might want to make an initial agreement and then amend it to add some of these details before you really get going and start actively bidding work. It's important to have these things in place and have them memorialized in a written agreement that's been negotiated between the parties. Third, management and control of the venture. As Aaron mentioned, it's essential that both joint venturees have a degree of management and control. But now that you are essentially merging the businesses into one for the purpose of this venture, it's very important that you know exactly who's going to do what. Who's running the accounting, who is overseeing project management, who is in charge of bidding. All those different elements that normally would be in-house at one company are now being shared between these two companies, and each company is going to have their own strengths and weaknesses. So identifying those strengths and weaknesses and exactly how the venture will be managed is essential, and what the hierarchy will be. How are decisions going to be made? Because the last thing you want to do is start this venture and all of a sudden you guys can't agree on the best path forward and you're in gridlock dispute, which is not a recipe for a successful joint venture. The next one is very similar: business and operational activities of the venture. So beyond just the management of the venture, well, what is the joint venture being put together to do? Is it being put together for a specific larger project that you're both well suited for? Or is it being put together to pursue a certain type of project and to pursue multiple projects? Whatever the scope is, obviously that can be changed, but initially the parties should be on the same page regarding what the purpose of this venture is, what the limits of the venture is. And that's more memorialized in the context of business and operational activities for the venture itself. Fifth, transfer of ownership interests. So because the joint venture is you're jointly sharing risk, you're jointly running the operation and sharing in profit, things can happen during a project. Things could happen with one of the underlying companies. What if a principal passes away or something else? There's a lot of things that can happen that could change the nature of the way the underlying businesses are being owned and run. So it's very important that in the context of the joint venture agreement itself, that it's spelled out basically what's going to happen should the control of one of the underlying entities change, should the capitalization change, should the licensing change. So that should all be spelled out in the agreement. 6, allocations and distributions of income and other assets. Again, you're splitting profits. It better be crystal clear exactly how that profit's going to be allocated and how any potential loss is allocated. Who's on the hook? and when, and if capitalization is needed, who's going to step up and how much? What are those expectations? And then finally, the term and termination of the venture. Most joint venture agreements are limited in term. A lot of them are limited to a single project. Others of them keep going, but generally you do want to have a defined term. That term can change. You might elect to have a new joint venture agreement for a new project because some of the details may be different. You can have a joint venture to go after multiple projects, but still it makes sense to set a term, and you can renew or adjust as needed. But setting forth, okay, well, what is the expected term of this agreement, of this venture we are going forward with, and when will it end? Is there a hard end date? The other thing that Sure.
I have a question. So if the joint venture is for a specific project and then it's outlined in the agreement, and then let's say a year later, something else comes up and you decide that you want to go after the joint, as a joint venture for another particular project. I'm getting, well, I just want to make sure, do each and every time there is another project, do we have to start all over again as far as starting like a new business, or can we amend that agreement?
You would be able to amend the agreement, and if you do intend to go after multiple projects, you might fashion the agreement that way in the first place. Usually it's tidier to amend the agreement because you get the benefit of the best of both worlds. Because once you've created this venture, you've complied with the legal requirements for its existence and how it's going to outwardly exist to the world, basically. But internally, there are specifics that may apply to a certain project. Maybe the financials are different. Maybe the commitments are different. That's probably something you're going to want to amend project to project. So what you could do is have any joint venture agreement, once you've created it, as long as you haven't allowed it to expire by its terms, you can amend that agreement to continue. So generally that's what we would recommend.
Okay, thank you.
No problem. And then the other thing to consider is ancillary agreements. So while you may be entering into this joint venture for the specific purchase, and it makes sense for the businesses to merge for this specific purpose, there may be other services that your business or a related business that you may control provides to your current business that you don't necessarily want tied up into the joint venture, or that's going to be adding additional value, unrelated services that really don't belong in the joint venture, but are still going to be necessary to the project that the joint venture is undertaking. In that case, usually what we recommend you do is have ancillary agreements specifically for that purpose. So for an example would be if the company happens to lease an equipment yard, and that equipment yard you intend to use as part of the joint venture, but you don't want, or maybe you own the equipment yard and you don't want to jointly give them ownership, and so what do? You may lease them a 50% share of the equipment yard for the purpose of the venture, or have some other sort of ancillary agreement to address that, to ensure that the value being added to the joint venture is commensurate with what the parties have agreed to. And there's a lot of other examples there, but that's one.
Hey, Peter, a quick question. You've articulated, you say, look, we've got to have a shareholders agreement or a joint venture agreement and put it in writing. That's the best practice, but can a joint venture relationship be created verbally or orally, not in writing?
Aaron, thanks for bringing that up. That's a good question. And the answer is yes, it can. You can create a joint venture just orally between you and another party. And that joint venture agreement, if you can prove that it exists, can be a legally enforceable agreement. And you potentially legally could even bid based on that agreement. We don't ever recommend doing something like that because of the substantial liability that you may face as operating as a joint venture. And of course, because at least in the context of the construction industry, most likely the joint venture is going to need to be licensed. So really, if you're going to go through the process of licensing the joint venture with the CSLB, you better have a written agreement between you and the other potential joint venturee. But yes, you could do that. And there is a exception with respect to the CSLB if both joint ventures are themselves properly licensed. That may be enough. So you potentially could get by that way, but we would never recommend doing business that way. Let's jump to the next slide, Aaron. So the next thing, and Aaron will cover this in more detail, but we should consider in the context of how the joint venture is created is what are the legal filing requirements? At the end of the day, they're really pretty thin, and you could potentially create a joint venture, maybe even almost inadvertently through a oral non-formal agreement with another party. There's no filing with the Secretary of State like you would for a new corporation or a limited liability partnership or something like that. So there's no Secretary of State filing requirements. You should have a separate CSLB license. There are some exceptions to that, but the best practice is always to obtain a separate license for the joint venture. It's going to protect you and the your fellow joint venturee, and it's going to ensure that you are properly licensed. And given the substantial risk associated with not being properly licensed, potential disgorgement penalties under Business and Professions Code 7031, it's absolutely the recommended path to make sure that the joint venture is separately licensed with the CSLB. Other requirements, insurance and bonds. Most of the time, it's going to be required that the joint venture be named on insurance, and also that the joint venture obtain the bonds for any project that the joint venture is bidding. We'll cover bonds in a little bit more detail in a few other sections, but generally what you do is you use the sureties that you're already having, that you're already getting bond capacity with. You cooperate with the other sureties, and usually one of them will take the lead bonding the joint venture, but will have the other surety participate. That's usually the simplest way to do it. A business license may be required for the joint venture depending on where the project is. That's going to be dependent on the county and city in which the joint venture is operating. And then finally, you may need to register the joint venture as a DBA, doing business as, depending on how the joint venture is representing itself. And we'll cover that a little bit more in some other sections. Let's jump to the next slide.
So let's, Peter's talked about, what's necessary to get it set it up in terms of the joint venture, but we'd like to, turn the conversation now to some of these important legal requirements. And some of these are ones that unfortunately we've had to deal with for our clients in some pretty dire situations. And contractor licensing is one of those areas where it's a hot button issue. because it's how the state regulates contractors in California. But also, as Peter mentioned, there are some severe economic consequences if you're not properly licensed. And unfortunately, we've had none too few clients come to us dealing with joint venture license issues where they're out of compliance and they're facing the risk of some of these dire financial consequences, which may prevent them from being paid and also require them to pay back all the money that they were paid just because they didn't comply with their contractor licensing requirements. So the law says that each joint venture must have its own contractor's license. So again, we have two different entities coming together as one. And so those two separate entities each must have their own contractor's license, and it must be current and active. So we first start out, with the baseline level, which is the two ventures have to have their own licenses in good standing. And this is part of that due diligence process that Peter mentioned, making sure that the other party can actually perform their side of the obligations. Can the other party, do they have a license, and is it maintained in good standing, or do they have some problems with their license? Then the joint venture can be issued its license, and the joint venture can receive a contractor's license in any classification. So there's you have the A classification, you have the B classification, and then you have the various C classifications for the trade work and specialty trades. And the joint venture can receive any of those classifications on its license, so long as at least one of the joint venture members is licensed in that actual classification. So for example, if you have two parties to the joint venture, one has a Class A license for general engineering, and the other has a Class B license for a general building contractor, and then they get a separate joint venture license. That separate joint venture license can have a Class A attached to component to it and a Class B component to it, so that the joint venture is licensed to perform contracts that require a Class A contract or a Class B contract, because at least one of the parties to the joint venture has those classifications. So by doing a joint venture, you can actually create an entity that has more license classifications than your own company if your counterpart to the joint venture is licensed in that specific classification. And the caveat here is that if any of the members to the joint venture fail to keep their license in good standing, then by operation of law, the joint venture license is suspended during that same period. And that's very powerful language in terms of statutory language being by operation of law. What that means is the CSLB doesn't have to find out about it and get a report or a complaint. They don't have to send you a notice letting you know that you're out of compliance and that there might be a problem. If it's actually proven that any individual that is licensed in the joint venture, their individual license has been suspended or it's no longer in good standing, then the joint venture license itself is suspended automatically. Nothing else has to happen. So if you're part of a joint venture and you're having licensing problems, not only is your company's license at issue, and you could be facing some of these severe economic consequences due to that, the joint venture itself could be exposed to those same exact circumstances.
I have another question.
Sure.
So then as a joint venture, it's impossible then to have a joint venture with, for example, my company that is professional, providing professional services. For example, like my company, we provide, we have expertise in certified payroll and compliance, right? And so we then partnered with another individual who has a contractor's license as a general contractor or an electrician, for example. And then we come together. My company does not have a contractor's license. So that means that professional companies like mine would not be able to go into a joint venture with someone as a collaborative to do a project together. Am I making sense?
Yeah, you are, Gene, and you've explained it, I think, very well. You're exactly right. The law is very clear, and the specific statute is right here. Is this Business and Professions Code, Section 7029, and the language of that statute makes it crystal clear that each party to the joint venture must have a contractor's license in order for the joint venture to receive its own separate contractor's license. And if that is not satisfied, then the joint venture can't receive its own contractor's license. And so in situations like that, one of the questions is, well, if the parties can't enter into a joint venture relationship because the joint venture is going to perform a construction contract that needs a license, and therefore all the parties in the joint venture had to have a license, is there some other form of business enterprise that the parties can utilize to still achieve their business objectives, right? And so sometimes an easy alternative to a joint venture is the subcontracting relationship. And so a licensed general contractor or a licensed subcontractor, they can enter into a contract with, let's say the owner or the general contractor, but they can subcontract out things that need to be performed. And those things can be administrative functions as well. So if there's certified payroll activities that the licensed contractor wants to have somebody else perform or assist them with, they can enter into a subcontract relationship. And there's other forms of business ventures that might be alternative solutions than just the joint venture. But yes, that's one of the important requirements to establish a joint venture if the joint venture is going to need a contractor's license because it's going to be entering into construction contracts and performing them.
Okay. What if one of the officers of the professional organization has someone that is maybe the treasurer or secretary of the organization of the company has a contractor's license?
Yeah, and so the individual who has sat for the trade and the business law tests for the CSLB, we refer to them as a qualifying individual because they can qualify a company to receive a contractor's license. However, if you have let's say an employee like a CEO or a secretary or treasurer or something like that has is a qualifying individual, can qualify the company for a license, they still need to apply for the license to be issued to the company, right?
Okay.
It's not enough just that person is employed by a company and then de facto the company is licensed. That doesn't happen. That qualifying individual has to make an application to the licensing board to say, I'm the responsible managing officer or the responsible managing employee of my company. I'm a qualifying individual and I'd like you to issue a license to my company, right? Then the company technically owns the license, or it's in the name of the company, not just the individual. And now the entity is licensed, and that might be one solution. It's a process to apply, so it does take some time, and it could take anywhere from a month or two to have an application and a license assigned. But that might be one solution.
Okay, and that's the RMO, right?
Right. So when it comes to licensing, there are two different types of qualifying individuals. And this goes for a corporation or a joint venture or LLC or anything like that. One is the responsible managing officer. So it's somebody who is an officer of the company, and they're a qualifying individual. The other option is to use a responsible managing employee, typically someone who is a superintendent, out there in the field, but is not really in the executive level, but is more on the employee project level. They can be responsible managing employee. There are some differences in terms of what types of things are required of an RMO versus an RME, but either of those can qualify the company to have the license issued.
All right, thanks.
Mr.
questions.
Flores, this is Kenneth Collins with Cubico
Yes.
Construction Services, General Contractor.
Hi, Kenneth. Nice to meet you.
Great. I have a question. After the joint venture, once it's licensed, it has its separate license. After 4 years, does that joint venture license become standalone? Meaning that it does not have to no longer qualify with the 2 other licensed entities.
No. So the law in California, again, and the relevant statute is this Business and Professions Code 7029, says that each member of the joint venture must hold a current active contractor's license in good standing. So although the license is issued to the joint venture and it's a separate license, right? Be clear about that. That license only is in good standing so long as each of the joint venture license remain current and active for the duration of the joint venture.
Okay, second question. If one of those members drop off, can another licensed entity step in their place and continue with the same joint venture, only a different licensed member?
Yeah, short answer is yes. The process there is to replace the member on the joint venture license with the contractor state license board, right? So you take one off and put the new one on, and then obviously do the same thing with the joint venture agreement. Remove the old party and then add the new party, and then as long as both parties and the new party maintain their license in good standing going forward, then you've completed the changeover and you're in good standing. You don't have any problems.
Excellent. Thank you.
My pleasure. Okay, so let me keep going here. So also along the lines of the licensing here, we have some important information. It's unlawful to be awarded a contract jointly as a joint venture or to act in the capacity as a contractor, so performing work or a contract, unless the joint venture has a license, right? So if a party says, let's enter into a joint venture, you guys agree, and then you don't have a license yet and you are awarded a contract or you sign a contract in the name of the joint venture, that's technically an unlawful act. And if you want to enforce that contract, you're not going to be able to enforce it in court because it's an illegal agreement. One of the parties who's required to be licensed is not licensed. In addition, if such an activity occurs, it's a basis for disciplinary action with the licensing board. So, you could have a letter of admonishment in your file, or worse, a citation, or some form of an accusation.
It looks like we might have lost Aaron. Peter, are you still there?
Yeah, I'm still here.
Oh, okay.
I guess let's give him a second, and if we can't get him back, I can just keep going.
Okay. Or what we could do, I know you mentioned wanting to take a break. Maybe we can do that now and then have some
Yeah,
time
that's
to-
probably a good idea. Yeah, we were thinking about
Okay.
taking a break at 5. So let's take a 10-minute break, and
Yeah.
we will come back at 5.
Okay, that sounds good. All right, we'll see everyone back at 5.
Thanks, everybody.
All right, we're all good, so we can get started.
Great. Thanks, Carlos. Thanks, Anna. So my apologies for the internet dropout there. I've switched lines. So we left off, we were talking about that it's unlawful to be awarded a contract unless the joint venture has a license, and that it can be a cause for disciplinary action. And for all of the requirements and the regulations for the license, that you can't contract in the joint venture name unless you have a license, and they can't perform work unless they have the license. The law does specifically allow an unlicensed joint venture to submit a joint bid, right? And so the idea is that in California, these very strict licensing requirements are going to be enforced strongly, but they are going to allow joint venture parties some level of flexibility, at least during the bid phase. And they don't have to have a license to submit a bid as a joint venture. But that's probably the one exception to this rule, that the joint venture must be properly licensed at all times. In terms of these severe economic consequences if licensing is not in compliance, there's really two that we see frequently, and they all relate to Business and Professions Code section 7031. Pursuant to that statute, if a contractor does not properly maintain their license at all times during the performance of an act of construction or a construction contract, then they're barred from collecting payment. And we've highlighted at all times because that's what the statute says, and that's what courts require in order to prove that you have the right to collect payment. And so what this means is if a contractor is engaged in performing work on a contract for the duration of 1 year, let's just say, and they have a 2-week period in that 1 year where their license was in suspension and they have no defenses to that and their license is merely in suspension, if at the end of that 1 year, the contractor goes and sues the owner to try and collect payment, and the owner catches this license suspension, the owner can take advantage of that and cite to this statute, Business and Professions Code 7031, and say, well, you didn't maintain your license at all times because you had a 2-week suspension, and therefore you're barred from collecting any payment, right? And the contractor's response typically is, well, bar me from collecting money for the 2-week period in which my license was suspended. And that makes logical sense and seems reasonable. However, we're stuck with this language in the statute that says you have to maintain the license at all times during the performance of the act or the contract. And courts will interpret that to mean if you had a 1-year contract and that's what it was, you had to be properly licensed for that entire 1 year. And if you weren't, you've lost your right to recover any compensation. And so it's severe, as severe can be. And unfortunately, it gets worse. Under the next subsection in the statute, 7031 subsection B, it states that the person who utilizes the services of an unlicensed contractor, which can include someone who does not properly maintain their license at all times during the project, then the person who hires that unlicensed contractor can sue to have the money paid back to them to recover all compensation. This is referred to as disgorgement. So on one side of this issue, if you don't properly maintain your license at all times, then you can't sue, let's say, an owner or a general contractor for payment, right? Bad situation. Even worse, though, not only can you not sue for the monies that are owed to you, the monies that you have been paid, you can be sued and be forced to return those back to the party who hired you. And so if a contractor is stuck with this type of licensing issue, whether it's a corporation or it's a joint venture, it can result in bankruptcy. It can result in catastrophic loss here because whatever monies they've not been paid, they're not going to get. And so how bad would that sting your company? And even worse, if you got to give back the money that you've been paid, that leads to a situation where people are thinking about how to file for bankruptcy and things like that. So it cannot be stressed enough how important maintaining your license truly is. Next, I want to talk about this concept of the members being fiduciaries of one another. The law is very clear that the parties in the joint venture are fiduciaries of one another. In the eyes of the law, the joint venture is essentially treated like a partnership. It's just limited in duration and purpose, right? So it's usually limited to a specific project, a specific construction contract, but it's going to be treated like a partnership in all other regards. And one of those obligations amongst partners are these fiduciary duties, and each fiduciary owes the other the duty of highest loyalty and utmost good faith. And so this means you cannot, in any circumstance, put yourself first over the other party in the joint venture. And so you can't get an advantage over the other party. And if you do get an advantage over the other party, the law presumes that it was obtained fraudulently, right? That's how important this fiduciary duty is. So when we're entering into the joint venture, we talk about, doing the due diligence, setting it up properly, getting your license to be in compliance. But now the parties have to treat one another, and they have to prefer one another, right? In the same way you have to treat a partner in a partnership agreement. And so we want to be mindful. So what does this mean realistically? It means that members must avoid, and I should really say they must actively avoid, any kind of self-dealing. So if they're on the project for the JV and there's additional scope of work that's offered to the JV, one member can't take that opportunity and perform it in their own company. They have to give it to the joint venture. Corporate opportunity, conflicts of interest, disclosures of conflicts of interest. There could be certain confidential information that the joint venture has by the nature of being in the joint venture that the parties can't disclose to other non-members in the joint venture in terms of what the plans are for the joint venture and things like that. So at its core, it's the duty of good faith and fair dealing, which again is the duty of highest loyalty and utmost good faith, avoiding getting any advantage over the other party to the joint venture. Next, I want to talk about some of the compliance issues with these handful of socioeconomic programs. Like I mentioned in the intro, there's a variety of different programs and certifications that are out there. Some are disadvantaged business entity, minority business entities, women-owned business entities, disabled veteran business entities, small business entities. You have all these different entity enterprises and certifications that larger contractors see as an opportunity to obtain bid preference. In California, there's many different statutes that provide for bid preferences. Some have been challenged and successfully challenged, others have not. But a bidder can get up to a 5% bid preference if the awarding agency puts in the bid documents that a bid preference will be given to a bidder who has, let's say, the DVBE certification, the Disabled Veteran Business Entity certification. And once that happens, larger entities, if they don't have those certifications and can't qualify for them, immediately jump to the joint venture opportunity. And so they'll solicit smaller contractors who perhaps don't have the same amount of bonding capacity, but do have, let's say, a DVBE certification and can qualify a joint venture to have that DVBE certification. Now that larger contractor is going to go bid and get potentially, a 5% bid preference. And I could tell you from personal experience, a 5% bid preference can make or break the bid. And in California, where most bidding on public works projects is a low competitive bid, if you have a $5 million contract, and then the lowest bidder is $1 less than that, they're going to get the contract. And if you have this 5% bid preference, that means that contract is going to you as a result, and it can make the difference of getting a contract or not. One of the important caveats is to ensure that whichever party is providing the certification for, let's say, the DVBE, that they continue to satisfy their control requirements to maintain that certification in good standing. Most certifications, like a DVBE or a minority business entity, will require that the person who qualifies for the certification have at least a 51% ownership interest in the joint venture, and that the person have ultimate say or operating control over the entity. And so if you think about this, you have the large contractor and you have the small contractor. The large contractor is providing really the money, the bonding capacity, financial resources. The small contractor is providing the certification. However, in order to make sure that certification stays in compliance, that small contractor has to have 51% ownership interest and have the final operating say and control over the day-to-day activities. And most small contractors don't realize that they have to have that compliance, and others maybe are just timid about stepping into that role, right? But if you don't satisfy that requirement, then your certification and qualification of the joint venture as a DVB entity can actually be lost. And in fact, the agencies who issue these certifications, a lot of times, particularly if it's a small business entity certification, where it's either a state or federal based certification, the state or federal government will have investigations and enforcement officers who will actually make investigations to the operations of the company. And when they do, they will look to make sure that compliance is happening, right? That the person certifying or qualifying for the small business entity or the DVBE, they own 51% and they have control and management over the company. And in my experience, when this happens, a lot of times this is something that the joint venture members have not even thought about. And the question is immediately presented, which is, well, what do we have to give the investigators to make sure that we're in compliance? And here's just a handful of things that you can do to make sure that there's a record of compliance. Having the qualifying individual for the certification sign contracts is an act of the company and shows management and control. Having the person sign checks shows that they're making financial decisions for the company. When you have meetings for projects and for joint venture business, make sure there are meeting minutes reflecting the attendance of that qualifying individual, and that they're having input into the decision making and the control. And the question really is, can you prove these activities with these documents if an investigator makes an inquiry, and can you provide that information and documentation quickly? I've had cases where the enforcement officer is making an investigation and requesting documentation, and it just takes forever for the client to get it to the investigator. All that's going to do is cause the investigator to drill down further and see what's going on there. These are things that you want to have as part of your process in the joint venture at the ready and able to provide to an investigator if and when they ask for it. The next important legal requirement is this business name, the DBA, that Peter mentioned. And the law in California is really clear that every person transacting business for a profit in a name other than the legal name of the company has to file a fictitious business name statement. And the purpose is just to let the public know who they're dealing with. And that's required by the Business and Professions Code. In short, you go to the county where you're operating, and it may be one county or more than one county, and you file with their clerk's office a fictitious business name statement, and that stays on file in that county. And then periodically it'll need to be renewed. And as long as you keep it renewed, then you're in compliance with any kind of fictitious business name requirements. The next item to discuss here are some of the tax aspects I want to make full disclosure here. FloresRyan LLP, we are not tax lawyers. We don't give tax advice, so always utilize a tax professional's assistance when it comes to these tax issues. But briefly, we can mention that the joint venture is considered a partnership, like I mentioned earlier, and so it's taxed like a partnership. Profits and losses are taxed at the ownership level, not on the entity level. And as a result of that, there's a lot of consequences to the individual members of the joint venture. And so when you're, in the due diligence phase of setting up your joint venture, you want to seek the advice of a tax professional, of a CPA, who can tell you how the joint venture is going to be taxed, set it up in a way that it works with your existing entity and the way that your existing entity has set up their tax management. So I can't say enough about the need to use a competent tax professional to make sure that is dialed in. There's nothing worse than when I have a client who has done a joint venture, put in a lot of work, and completed a project successfully, and then when they think they're going to have their final draw and really make the profit of the project, they realize there's a big tax bill waiting for them. It's just a real damper on the whole thing. So Peter is going to talk to us now about the bonding requirements for a joint venture.
Thanks, Aaron. So the bonding requirements for a joint venture are similar to the bonding requirements for any company that's getting a bond, either a bid bond or a performance bond for a project. In considering these requirements, it's important to consider that three primary parties to a bond, that is the surety, the one who's issuing the bond, the principal. The principal would be the party that is being benefited by the bond, that the bond is intended to backstop. And then the obligee, and the obligee is going to be the party that's purchasing the bond or obtaining the bond, underwriting it. At this point, for the purpose of a joint venture, the joint venture is going to be the obligee on the bond rather than the two joint venturees. But the two joint venturees are most likely going to be required to underwrite or to sign off and pledge their respective capital to support the bond. A joint venture usually does require its own bond package. So most of the time, potentially a private owner might accept bonding by joint ventures. Under most circumstances, it's going to be required that the joint venture itself actually obtain a bond and a bond package, both to bid the project and if they successfully win the project. The sureties will underwrite the finances and capabilities of both JV counterparts. So you do have the benefit of being able to have additional bond capacity if you have, by virtue of having the two partners there. And that's one of the benefits, especially on larger projects, of forming a joint venture, is creating the bond capacity necessary to bid a very large project that individually you wouldn't be capable of bidding. This comes with a caveat that sureties do not look favorably on what are referred to as angel deals, in which one contractor effectively lends his balance sheet to the other in order to allow the latter to bid a project. Basically, so instead of there being two joint ventures that are combining to increase their bonding capacity, in this situation, you would have one joint venture that really isn't actively participating in the project, is really just a joint venture for the purpose of meeting the bond requirements, and that is not looked upon favorably, and we also don't recommend it because of the substantial risk that silent joint venture would be undertaking. Sureties of joint ventures generally what happens is you've got the sureties of the joint ventures partners themselves that will come together and come to an internal agreement regarding indemnification. So what that means is, while there's going to be one surety under most circumstances that is actually underwriting the bond itself, in the background, you will have multiple sureties signing on to indemnify, usually at least one from either side. There are situations where multiple sureties will be listed on the bond itself, especially if it's a particularly large project. But it's more common that one surety officially underwrites with other sureties participating silently, basically. This may involve personal indemnifications of the owners or officers of the joint ventures that may be required if there's not sufficient assets or a sufficient balance sheet within the joint venture parties themselves. And obviously that adds an additional element of risk, because now you're exposing your personal assets not only to the company, to the project, but to a joint venture, and you've got the risk that you might not be able to control as well because it's a third party. Let's jump to the next slide.
So we've talked about a number of things, but really where the joint venture success lies is, making sure the parties have a conceptual understanding that's correct and the right expectations, making sure that they've gotten into position by creating the entity, getting their license, and those things. But the rubber meets the road, so to speak, when it comes to managing the joint venture. Unless the joint venture is managed properly and ran and given the attention like a completely separate business, chances are the management piece can fail and the profitability of the venture is going to be then lost. So the management is key. So what I want to do is discuss a little bit about this management. Peter already talked about the joint venture agreement, or what's referred to as a shareholders agreement, but I want to just briefly touch on the things that you should be aware of in terms of the actual day-to-day management, which also should be addressed in that shareholders agreement or that joint venture agreement. And the reason is that as the parties proceed forward in their venture, I guarantee all of these issues are going to pop up in the day-to-day management. And so not only knowing to expect them to pop up, but knowing what the agreement says itself and what the parties have already agreed to is critically important to make sure that that management piece is as smooth as possible. The initial capitalization of the venture is critically important, particularly if the joint venture is going to be doing work for a residential owner. The contractor, in most instances, is going to be required to, cover the overhead for the initial portion of the project, right? And so whether that's ordering materials or getting through their first payment application with the owner, all of those activities require money, and that money comes directly from the joint venture. And by now, I would expect most of you, if not all of you, are intimately familiar with the fact that a contractor's success ultimately depends on their cash flow and their management of cash. And so this initial startup phase of the joint venture is important, because if one party realizes, hey, we need more money for whichever resource that is required in the project, that needs to be addressed in terms of how it's going to be resourced in the shareholders agreement. And so if there's going to be a capital call contribution or there's going to be a loan taken, those are critical things to understand how that will happen. So if and when the need for additional capitalization arises, it can be tapped into immediately, and it's doesn't have to be put together from scratch. In terms of the scope of the work that's going to be performed, what happens a lot of times in these joint ventures is, like I said, you have the large entity and then the small entity, And the scope of work is a lot of times based on what scopes the entities are comfortable performing. Maybe the larger entity is more familiar, more comfortable doing, framing and concrete and some of the rough trades, but maybe the smaller entity is much more comfortable doing, drywall, tile, finish type trades. Things like that need to be articulated in the joint venture agreement. Management and control is critical. One of the things that will typically be set up in a joint venture is a management committee, where it'll be a committee of people from all the different members in the joint venture, and they'll have different voting rights, duties, and responsibilities that they're responsible for, and they can make decisions about how the company will manage, how the projects will be managed, etc. And it's a formal designation that is spelt out in the joint venture agreement and should be utilized. And then we have, just the traditional business operational activities. Peter mentioned about the transfer of ownership interests, allocations of distributions of income and other assets. Obviously, that's the purpose of the joint venture is to make profit, to get paid. The surety bonds, insurance, records, and accounting. And then it's something we don't like to have to talk about, but we do because we're lawyers. But there should be a provision in the joint venture agreement that says how the parties deal with disputes and differences. Not every dispute between venturers needs to be a scorched earth, out to get you and the company type of dispute. And to avoid disputes escalating to that level, it's better that the parties understand what their rights are when it comes to disputes. So is a dispute going to have to be arbitrated in private arbitration, or is it going to be litigated with the courts? Is there a mediation procedure that's going to have to be complied with before somebody can file arbitration or a lawsuit in court? Understanding what those things are critical. And then the voting rights. The agreement will specify what the voting rights are. Traditionally, the voting rights are proportionate to the amount of ownership interest in the entity. So if one entity has 51% ownership interest, they're probably going to have a greater degree of voting rights, but that's going to be spelt out in the joint venture agreement. And then lastly, the term and termination of the venture. Peter had mentioned about, these joint ventures are for a limited duration, but what happens if during the project or the venture, one party wants to end the joint venture agreement and end the relationship? The joint venture agreement will have a provision of how that can happen. And unfortunately, this happens when one party isn't performing their side of the bargain, and the other party to the joint venture can't make up the slack from the other party and says we've got to terminate the joint venture, which also usually means they have to terminate the contract that they're working on. And that process needs to be spelt out in the joint venture agreement. And it's one that you should be familiar with. None of us like to ever, think about, an entity failing or an enterprise failing, but understanding what that looks like and how it can occur by reading the termination provision is critically important. And so these are the hallmarks of a good joint venture agreement in terms of what it should address, but more specifically in terms of the management, these are the things that the parties to the joint venture need to fully understand, be familiar with, and have a day-to-day knowledge of in terms of when they're running the joint venture. So that's at the joint venture level. Now we get deeper into this management issue, probe a little bit further, and talk about the actual project management. So we have the joint venture entity and everything that's required to set it up. Like I said at the outset, imagine all the effort you put into setting up your companies that you have today. Now double that effort and all those things you had to do to set up the entity. Now you're in business with a joint venture, but now the joint venture has to actually run the project, right? The traditional project management stuff needs to be addressed. And a lot of these questions are similar to how the joint venture will be ran, but more targeted towards the project. How will the project be capitalized? How will employees be paid? Will the joint venture be issuing paychecks, or will the respective joint venture members pay their own employees, right? who will manage the construction contract, right? Is there someone that's going to be responsible for all the scopes of work in the contract that are performed by the large entity and the small entity, and manage contract issues? Who's going to manage the project schedule? If there's updates that are needed, if there's a 3-week or a 5-week look ahead schedule, who's going to be doing that? What about contract billings? Who's going to prepare the contract billings? What's the process for preparing those contract billings and make sure they get out the door? What if the joint venture has subcontractors and suppliers, right? Who's responsible for managing those parties and their bills? Who's going to manage day to day? How will claims and litigation be handled? Sometimes the joint venture may do everything correct, but the owner says, "I'm just not going to pay you," or they pick a fight on some scope of work issue. How are those claims and litigation going to be dealt with? Is there going to be infighting amongst the two joint ventures, the two joint venture members? Maybe one party says, it's not worth it to pursue the claim, let's just walk away from it. Maybe the other person says, let's go for it, and there's a different appetite for risk. So understanding how that's going to happen and having an understanding is critical. Will there be regular project meetings with meeting minutes? And how will the licensed qualifiers exercise direct supervision and control? The licensed qualifiers have the obligation in California to exercise direct supervision and control over the construction operations. There's a variety of different ways how that can actually be satisfied. It can be satisfied by the qualifying individual actually being present on the job site, reviewing for correctness of work and quality of work. It can also be satisfied by the qualifying individual being involved in the day-to-day activities, but not at the project, but still having day-to-day input and decision making in terms of critical project decisions and things like that. And just like the discussion we had about the disadvantaged business entity or the small business entity, if an investigator comes looking, you want to have the documentation and the evidence that you've satisfied your obligations. Same thing with the qualifying individual's responsibility for direct supervision and control. You want to be able to show that qualifying individual has visited the project, is making critical decisions, is copied on emails for critical decisions, is sending out correspondence about critical decisions of the project and management, and actually be able to prove those things. If you're not focused on how that will happen, you could be surprised, if you get into a legal lawsuit where the other party alleges that, hey, your licensed qualifier was just a sham qualifier. He never satisfied direct supervision and control. And as a result of that, you're an unlicensed contractor. And unfortunately, that does happen. I've been on both sides of that, making that argument and defending that argument. And if a contractor has not been thoughtful and making sure there's evidence to show direct supervision and control, it can be a nasty fight that you don't want to have. So these are some of the management, day-to-day management things on the project level that you need to be aware of. In terms of the project level, the ball that you want to keep your eye on is the construction contract documents. We're probably all familiar with that term, contract documents. If you ever submitted an RFI to the architect or engineer about something and they didn't want to give you a straight answer, their response probably said, contractor follow their own means and methods so long as it complies with the contract documents or something like that, right? Just punting to this contract documents idea. But it's critical because that defines all of the obligations of the joint venture and what they have to do. And so traditionally on most public works of improvement, the contract documents are going to be made up of these items that we've put on the screen here. There's going to be an invitation for bids and instructions to bidders. There's going to be approved set of construction plans. There's going to be a set of technical specifications that really explain how the project's to be built. There's going to be the actual agreement for construction that says what you're building and the price. A lot of times there'll be a project manual that's basically a roadmap of what the owner expects in terms of how the project to proceed. There may be general conditions stating, certain things that have to be maintained at the project and the process and procedure for doing billings, RFIs, change orders, etc. And there'll be supplementary general conditions if it's a larger project. There could be special conditions as well, which are more detailed requirements of the contractor that they have to follow. And then there could be addendums and modifications to the contract as well. But when you hear that term contract documents, this is the list of items that should pop into your mind. And again, it's important because each of the items in these set of contract documents creates some type of obligation that the joint venture must satisfy. And so in terms of the day-to-day management of the joint venture, it's critically important that the joint venture management committee fully understand each project's set of contract documents and the obligations that are created in those documents. I want to talk for a second, though, specifically about the construction contract, right? This is where these obligations are going to be most pronounced or most clear, I should say. And some of the key contract provisions that you want to be aware of that the joint venture has to satisfy is obviously one, the scope of work, right? It's going to tell us what we need to do. Second is design responsibility. In most construction contracts, you're going to have a couple of different options in terms of who holds responsibility for the design. In a lot of the contracts, if it's a design, bid, and build contract where the owner puts together the design and then puts it out for bid and then the parties build it, that design responsibility in large part is going to be the owner's design responsibility. They hire the architect or the engineer, draft up the plans, they're responsible for it. But sometimes that design responsibility is shared. And so if you have a project where the plans are drafted up, but they're not drafted up to 100% complete, maybe they're drafted up to like 60 or 70% complete. Maybe you only have a set of architectural drawings. You don't have a set of mechanical, electrical, and plumbing drawings. The contract may say that the plumbing contractor has the obligation to submit a set of shop drawings showing where the plumbing is going to be installed, how it's going to be installed, the routes, and things like that. You want to read your contract to make sure you understand what that design responsibility is. And if you have any questions about it, you want to submit an RFI and clarify before you start work. There's going to be a change orders and claims provision. We all know what the change order does. It modifies the original contract. It can modify the original contract in terms of the project time to perform the work. It can modify the scope that's going to be performed. It can add or take away scope, and it can change the price. It can increase the price or reduce the price, right? Time, scope, and cost can all be modified by a change order. And then the circumstance is probably going to happen where there's going to be a change order dispute at some point, and the contractor says, I'm owed a change. The owner says, you're not owed a change. In most construction contracts, in addition to the change order procedure, there's going to be a claims procedure. And not only is there a procedure that you have to go through for these claims, there are strict time limitations that are required to be satisfied in order to preserve your claim. So hypothetically, there's a change order submitted, it's rejected by the owner, and it's clear that the owner is not going to change their mind. Once that happens, it triggers this time limitation on submitting a contractual claim under the terms of the contract. And if you don't timely submit it, you run the risk of losing your claim altogether, meaning you can't sue the owner for that change order and recover payment on it. You have actually waived your right to receive any compensation. So there's the change order provision that you want to follow and make sure it's followed exactly. And if the change order is not resolved successfully, then you want to be mindful of what the claims procedure is and making sure that you're timely cooperating and following the claims procedures. There's going to be a provision probably in the contract about differing site conditions. On public works of improvement, there's a statute in the public contract code that requires a public owner to give a contractor a change order for a differing site condition on projects where they're digging more than 4 feet below the surface and the condition was unexpected. So that helps to give you some backing, but the contract is going to specify additional terms when it comes to differing site conditions and who might be responsible for it. Schedule and delay, very similar to the change orders and claims procedure. Schedule and delay is important because if a party needs more time to perform the work and they think that they're entitled to more time to perform the work, they have to submit a request for a change order to increase the project time. And if they don't do that, then legally they're not entitled to additional time to perform the work. So sometimes the way this plays out is you'll have a contractor who has a change order because of a differing site condition, let's say, and that really should add 30 days to the project schedule. If the contractor never submits a change order for a time increase for the additional 30 days, the contractor never receives those additional 30 days to complete the work. And if he performs the work past the original contract date, they run the risk of being assessed liquidated damages, which is a per day penalty that the owner can charge the contractor simply because they didn't go through the process of getting a schedule extension pursuant to the contract. Insurance, surety, and indemnity. There's a lot that can be said, but I want to keep us on track here. But these things are critically important to understand, how to manage your risks, risk transfer to the surety or to the insurance company or to another party through indemnity. Obviously, payment is important. Continue to work. Sometimes the parties will get into disputes, and if there's a continue to work provision, it'll require the contractor to continue to work even though that there's an active dispute. And if the contractor stops working, then they can be terminated. And then we have a default termination and dispute resolution provisions. But these are the actual construction project contract provisions that you want to be mindful of and that the management committee in the joint venture should be mindful of as well to make sure that they are diligently managing the risks. There are some unique risks associated with public works projects, particularly for joint ventures and challenges for joint venture management. I'm going to go through these quickly because I want to get to the Q&A at the end here. The most important is that public works contracts are governmentally funded, and that means that there cannot be any conflicts of interest by the government officials. So on private projects, a lot of times the owner and the contractors, they know each other, they have lots of different deals to do the construction, and that may involve the owner having some kind of interest in the deal beyond just receiving the construction. It's radically different on a public work of improvement. You cannot have those types of relationships. Other things on public works, there's limitations on how a public owner can actually contract. And the thing to remember is the public owner is limited to the authority that they have in the contract to be able to modify the contract. And this is most clear when it comes to a change order. The public entity can only operate through the defined change order procedure in order to modify the contract. So if the contractor wants to add scope of work, add time, or add cost to the project or to the contract, they've got to follow the change order procedure, which usually requires the change order to be noticed within a certain amount of time, the change order to be written in writing and signed by the owner, and then the contract is modified. If that procedure is not followed, the contractor runs the risk of basically performing the work for free and not getting a time extension. And there's been some severe cases of that occurring. The other thing with public entities, public works projects, is that there can be multiple agencies having jurisdictions. Sometimes these projects are federally funded, so there could be the USDA or EPA agencies having some kind of oversight on the contract and performance. The state agencies, you'd have DSA, Department of State Architects, involved in having some type of regulation on the plans, and you'll certainly have the Department of Industrial Relations monitoring the prevailing wage situation, making sure that's in compliance. We have a bonding requirement on public works projects starting at the bid phase. And so you have to submit a bid bond, which is based on your credit worthiness. And that bid bond then can be lost if you are awarded the contract but don't follow through and accept the contract. And it really covers the cost of the public entity having to rebid the project. And that's what you'll be on the hook to pay. Then there are payment bonds. Payment bonds are issued for the benefit of anybody who has performed work on the project. So if you're the general contractor on a public work of improvement, you're going to have to furnish a payment bond for the benefit of your subcontractors and your suppliers. In the event that they're not paid, they can make a claim on it and get paid through the bond, and you have to indemnify the bond surety. And there are also performance bonds. The performance bond guarantees the general contractor's completion of the work. And if a general contractor fails to complete, then the owner can make a claim on the performance bond. And then the performance bond surety has the option to either provide a completion contractor to complete the work, or to tender money to the owner in an amount necessary to get the project completed. And once that happens, then the bond surety comes back to the general contractor, the joint venture, and payment has to be made to reimburse the surety. Lastly, on unique challenges on public works is this concept of debarment. A public works contractor can be precluded from bidding public work if after a full hearing on the matter, it's determined that the contractor is a non-responsible bidding party, or they've engaged in some type of false claim, or even if there's unsatisfactory contract performance and an unwillingness to honor your bids, you can actually be debarred with the public agency. And I've had these cases where a contractor is accused of making a false claim, a claim for payment that they weren't entitled to, and along with the threat that they've made a false claim is a threat by the public agency that they're going to debar the contractor and never let it perform work in their agency again. And so a lot of times joint ventures are kind of a niche entity because they're targeting specific work, and a lot of times for a particular public agency. And if that joint venture is debarred for one of these reasons, then the opportunity to perform further work can actually be lost, which is catastrophic. So we've covered a lot here, but Peter is going to talk big picture in terms of some of the pros and cons associated with the joint venture.
Thanks, Aaron. I mean, now that we've covered all the details here, we're going to kind of back out to the big picture here of just kind of the general pros and cons of whether or not to go forward with the joint venture. We'll start with the benefits. The benefits, probably one of the primary benefits is just to spread the risk between partners. The larger the project, the larger the rewards a lot of the times, but also a lot of the risk should things go wrong. Should you be subject to unforeseen risk or increase in costs? And should there be a dispute and you be forced to continue on the project, if you've got two people and two companies involved, you're more likely to be able to weather that storm, continue to perform until the end, and then resolve the dispute, whereas a smaller company that was alone might not be able to handle that, even if it wasn't necessarily their fault. Another big benefit is the combination of specialized knowledge and abilities. You can joint venture, while both parties need to have a contractor's license, you can joint venture with companies that have different categories of licenses. So in doing that, you can bolster your abilities and be able to expand the scopes of work that you are able to perform in the context of the joint venture. It also allows you to more accurately have a more accurate and complete bid. I mean, any general contractor can include in their bid subcontractors, but you're never going to have as complete and accurate of a bid with subcontractors as you would with a joint venture partner who has the same skin in the game as you would have. So that's another benefit. Another potential benefit is to facilitate deeper local knowledge and cooperative business arrangements. The state of California is a large state, and there are opportunities all over the state. But if you're moving into a new area, you might not have the business relationships with subcontractors in the local community that would benefit you in operating in that new environment. Having a joint venture partner that's more familiar with that territory can be invaluable. Increasing bond capacity is probably one of the most talked about reasons that joint ventures exist. That's because, especially with the mega projects that we see today, it's impossible to bond them with just one entity. So you get entities combining to bond these very, very large projects. But the same thing can apply when you're talking about smaller entities that are uniting together to bond mid-sized projects that they would not be able to reach otherwise. And then finally, just kind of the general benefit of pooling talent, resources, equipment, materials, and everything else. There's a lot of benefits if you can get on the same page, get the trust, get the documentation. There's a lot of benefits to being able to put together a joint venture. Now we're going to go and talk about some of the risk that you need to consider, because while there's tremendous benefits to engaging in a joint venture, it's not without risk. The biggest risk would be the joint and several liability for the obligations of the joint venture. You share in the profits of this joint venture. That means that you also share in the losses. If the project is a losing project, you both are going to take that loss. And the risk, unfortunately, on the negative side can be greater than the profit side, because if something should happen to your joint venture partner, you still are going to be on the hook for the total amount of any loss if you're not able to recover it from your partner. So while you may have internal agreements regarding who's responsible for what, at the end of the day, if your partner goes bankrupt, you're still sitting there and you are jointly and severally liable for the whole obligation. That the biggest risk there occurs when you're talking about a small and large joint venture partner, because should something happen to the large joint venture partner, the obligations could completely wipe out the small partner. So while it may seem that if you're relying on a larger joint venture partner, you have less to worry about, that's not necessarily true. Because of the exposure you're taking on, it can be very risky to take on a larger joint venture partner that you're not comfortable financially with. Another risk that we see that can interrupt a joint venture is the overriding desire of each partner to maintain separation, which can result in conflict. I mean, while these companies are effectively combining for this one project, they still are their separate entities internally with their own long-term goals. And maybe even it's possible that they could be competitors in other contexts. So there can be some friction there that can cause issues. So you want to make sure that's another reason to make sure that you are on the same page and to think about those risks. If there was, or is there going to be any incentive for my partner to withhold things from me, not to give their 100%, or not be completely transparent because they are running a separate business and perhaps they don't want to let me in on every intimate detail. So that's another thing that can become a problem. There's obviously the just general financial and business risk that goes again into the joint and several liability issue, among other issues. Legitimacy or legality of the joint venture structure. Aaron went through in good detail the possibilities of having joint ventures where one of the partners could supply the ability of a minority-owned business or another designation, but there are strict legal requirements for that. And if they're not met on the internal side, if there is an audit, the legitimacy of the joint venture could be called into question. So it's another hurdle, and you have to be prepared to make sure that your joint venture is following all the requirements for the benefits that you are trying to achieve with respect to the project. And then finally, risk of inadequate disclosure agreements and planning. That's again the risk of failing to have everything you need in that joint venture agreement, failure to being on the same page, and failure to making sure that you've done that due diligence, that you're satisfied with the financials, that you're satisfied with what's been disclosed to you. Because if you discover things down the line, once you are already in a project, you might have legal grounds against your joint venture partner, but you're in it at that point. You're subject to the risk, and there's only so much you can do. So that is a risk that can't be ignored. And with that, we're going to jump into our Q&A. We're almost out of time, but hopefully we can run through a few of these really quick. Aaron?
Yeah. Carlos, think we can get through one or two of these in the time?
Yes, yeah, we were scheduled to end at 6, but so we understand if people have to log off, but we do want to get to one or two of these scenarios just to kind of drive home what's been discussed today. And then we'll take some questions as well, if there are any.
Yeah. And I'm happy to stay on as long as anyone has questions or wants to chat. So what I've done is we put a few questions together as conversation pieces, and then let's go for it. So here's the first question: is there's a large contractor who tells the small contractor that it has a job that it wants the small contractor to help out with, but doesn't clarify what role the small contractor is gonna play. Right? It probably sounds familiar. During a meeting between the project owner, the large contractor, and the small contractor, the large contractor tells the owner that the large contractor and small contractor are a joint venture, right? So we have representation. And after the meeting, the small contractor tells the large contractor that it agrees to act as a joint venture for this project with the large contractor, right? So they have a verbal agreement. And so the question here is, has a joint venture agreement been created between the large contractor and the small contractor? Does anyone care to take a stab at the answer to the question?
I believe no, unless in your previous explanation of a verbal agreement, someone agrees to it, but per state law in CSLB, both entities have to be licensed, not just making a statement in a meeting.
Okay, that's a good answer. Anyone else want to put an answer in?
I would say yes, because as you indicated, Aaron, it can be verbal. And this was from this scenario, it's verbal that the large contractor indicated it's a joint venture. Oh, no, I changed my mind, because it says here after the meeting, the small contractor tells the larger contractor that agrees. So no, because they were having a meeting prior to that, and only one stated it's a joint venture. So it transpired after. Then the other one said yes. So I don't think so.
Well, I think you both raised really, really good comments. I think you are both mostly correct. But a verbal agreement for a joint venture is enforceable as between the joint venture members, right? So here, between the large contractor and small contractor, there would be an agreement for a joint venture. But as Kenneth pointed out, the real question is, are they in compliance, and can they take a contract and enter into the contract now with the owner? And they can't do that until they get the joint venture license. So I think you are both correct in the way you answered the question. Carlos, should we do one more, or do you want to stop at 6?
Oh, sorry. Let's get through one more and then take some questions, and I think we'll be good.
Sounds great. Let's see here. Let me do the next one. Here we go. Question number 3. Large contractor and small contractor enter into a written joint venture agreement to perform a fire alarm upgrade project for a public school district. Okay, so they got the joint venture agreement. That's good. Large contractor has a B contractor's license, and the small contractor has a C7 low voltage, a C10 electrical, and C16 fire protection license, right? All of these license classifications are issued to the joint venture as a separate joint venture license. Okay, so they got their own license and these classifications. However, the owner only requires a C10 license to perform the work, right? So we have the large contractor with the B license, we have the small contractor with the various C licenses, and all those classifications are added to the joint venture license for the joint venture. During the performance of the work, however, the large contractor's license gets suspended because it failed to pay an outstanding judgment, right? So now we have one party who has a license that's not in good standing, but the other party has the C10, which he is in good standing, and that's what's required to perform the work. So the question is the joint venture's contractor's license still in good standing, given the fact that the large contractor's license is suspended? Anyone want to take a swing at the answer?
No. The joint venture's license becomes not operable because one of the partners have lost the ability to do licensed contract work via the suspension.
It's a good answer. Anyone else want to give an answer? Well, I think, Kenneth, no one wants to give an answer because your answer is correct. Even though here, the owner is only requiring the C10 license and the small contractor has maintained their license correctly, and that's in compliance, because both parties did not properly maintain their license, joint venture license is automatically suspended, and so the joint venture license is not in good standing. Great answer, Kenneth. We have two more, or we can just take some questions if anybody has any questions, but I'll stay on as long as anyone has any questions and wants to chat. But Carlos, it's your call.
Okay, yeah, let's go to some questions. Before we do that, we understand if anyone has to leave, we're a little bit over time, but I do want to make sure we give you an opportunity to ask questions. But just for if you do have to leave, thank you guys for joining us. We will send out the copy of the presentation and the link to the recording to everyone. So if you miss anything, you'll be able to go back over it. So yeah, so if you have any questions, please feel free to ask those now.
Hi, I have a question. My name's Theodora, and I wanted to know, do you guys handle other construction matters in addition to joint ventures? So for example, if I've got a contract that I'd like you guys to review, is that something that you would handle?
Yeah, absolutely. Nice to meet you, Theodora. We do everything related to construction law. So whether it's putting together construction contracts, modifying them, counseling in terms of a contract dispute, we can definitely handle that for you. So whatever you need, just email me afterwards and we'll get right back to you.
Thank you.
And I believe your contact information is at the end of the presentation, right?
It is. Let me just put
Okay.
that on the screen really fast here for everybody.
Yeah.
There it is.
Yes, and if you do reach out to them, please let them know that you participated in this workshop so they understand who you are. I'm sure they probably get a lot of emails every day like all of us, so that will help them understand where your questions and information is coming from. Do we have any more questions? Okay, I'm not hearing any. So I just want to thank you both, Peter and Aaron, for your time this afternoon and just giving us all this information around joint ventures. So I know we have a lot to chew on and go back to, but like they said, if you have any questions or you need any consultation, please reach out to them directly. They will communicate with you and let you know how to proceed from there. Is there anything else anyone wants to add, either from Meriwether or BTAC? Anyone?
Yes, I also wanted to say thank you so much for the presentation.
Thank you for the opportunity to present and share the information and experience with everybody. We sincerely enjoy it. And if you have any questions or want to chat about something, don't hesitate to reach out, and we'd be happy to connect with you online or a phone call or in person if it's necessary.
All right. So I guess we will end this workshop here. Thank you all for joining us. Have a great evening.
Thanks, everyone.
Thank you.